Okay, ladies and gentlemen, it's my pleasure to welcome you all to this SAILS Summer Conference on Law and Artificial Intelligence. For those of you who don't know me, my name is Bart Christus, and I will be your host for this afternoon. I'm a professor of law and data science and the director of eLaw, the Center for Law and Digital Technologies here at Leiden University. But today, I am welcoming you not only on behalf of eLaw. I would like to emphasize here that this event was initiated by several research groups in our law school, including the departments of public law and private law. I regret that we are hosting this event online because I would have liked to welcome you all in the Lawrence Hall in Leiden, which you can see actually here on my background. I do hope that having this event online allows more people to join us today actually, but nevertheless, I would have preferred to meet you in person, and I hope I can meet you in person at our next event. So today's program is about law and AI, and artificial intelligence represents the progress of science. It offers possibilities, until recently unimaginable, that can solve problems faster, better, and more innovative than ever before. Yet, while such new technologies may provide hope and change, they inevitably disrupt how we conceive reality, leading us to question and challenge existing norms and push us towards an increasingly louder call for legal change. However, while technology's pace dramatically accelerates, legal responsiveness does not always follow up as a consequent next step. But lawyers and lawmakers are increasingly paying attention to this. A major step forward is that the EU very recently released legislative proposals for regulating AI. And this is a very ambitious proposal, I would say unique in the world, as no other country has ever proposed anything like this. Obviously, this proposal sparks much discussion among scholars, raising the question of whether these rules will provide enough safeguards to ensure AI is safe for society. And it is this topic and other topics that we will discuss today. You probably noticed in the invitation or on the agenda that this is a SAILS conference. For those of you who are not familiar with SAILS, SAILS stands for Society, AI, and Life Sciences. This is Leiden University's €5 million research program on AI, facilitating collaboration across disciplines. And Leiden University has explicitly decided to focus AI research not only on the area of science and technology, but to include social sciences, humanities, law, and other disciplines in this program. And in this way, science can be advanced while also improving the quality of daily life. Now let me turn to today's program and the speakers. In today's conference, we will explore how AI impacts society from a legal and regulatory perspective. In particular, we'll focus on three main topics. The first part will focus on advances in the regulation of AI, and we will obviously also address the regulation I just mentioned. The second part will focus on AI interacting with the law, and the third part will focus on teaching law and AI to future generations. We are proud to have so many excellent speakers and panelists lined up in the program of today. The presentations will be short so that we can address many things from many different perspectives. Also, there's plenty of room for questions and discussion, and hence I would like to invite you all to raise questions and participate actively in a debate that we can have together. Well, I hope you will all enjoy this afternoon, and now I would like to get started immediately by introducing the first speaker. So we start with our keynote speaker, and that is Katelijne Muller. She is a president and co-founder of LA, an independent organization that promotes responsible development, deployment, and use of AI. She's also a former member of the EU high-level expert group on AI that advised the EU on strategies on how to deal with artificial intelligence. And she's an advisor to the Council of Europe on the impact of AI on human rights, democracy, and the rule of law. Well, dear Ms. Muller, Katelijne, the floor is yours.
Thank you very much. Thank you, Bart. Thank you, Eduard, also for having me. In April of this year, we finally got to see the highly anticipated legislative proposal for AI of the European Commission. It is a regulation, a product regulation, as a matter of fact, and to be honest, quite an ambitious one by the first looks of it. The Commission basically wants to project a very clear message. Fundamental rights are at the core of Europe's approach to artificial intelligence. And Europe is basically saying, when it comes to AI, anything goes is no longer the norm. We will not allow everything just because it can be done. And we don't just regulate bits and pieces of the technology, we set EU-wide rules that will hopefully resonate across the globe. So this is a milestone, as Bart already said. Europe is the first in the world to set an all-encompassing legal framework for what it calls trustworthy AI developments. And this is something that I've been advocating for since the very beginning at European level, and mostly together with Virginia Dignam, my co-founder at ALLY, who was also a member of the high-level expert group on artificial intelligence, who will be speaking later. And what I want to talk about today is, does the proposal of the European Commission live up to its promises? The promise of human centricity, the promise of trustworthiness, of ethical alignment, of value alignment, or perhaps more visionary, does it indeed do what we want it to do, lead to a society with AI that we want, and does it avoid a society with AI that we don't want? So the proposal puts down some red lines, which helps. Certain AI practices will not be allowed in Europe, but to be honest, the lines are blurry and they leave ample room for interpretation, with a lot of exclusions and inclusions that are difficult to understand, especially if you don't have a legal background. And this has already led to a very strong position of the European Data Protection Board and the European Data Protection Supervisor. They call for a general ban on any use of AI for automated recognition of human features. So that includes our faces, of course, but also our gait, our fingerprints, our DNA, our voice, our keystrokes, and so on, and other biometric identifiers, if you will. They also recommend a ban on using these types of systems to categorize us, to put us in certain categories that are considered to be discriminatory. And finally, they also call for a ban on AI that is supposedly inferring our emotions, the affect recognition, if you will, behavior recognition, things like lie detection, things like recognizing by the tone of my voice in an interview for a job if I will be a leader or if I will be successful in the job. I mean, there's not enough scientific evidence that that can even be recognized by humans, let alone by AI, but the EDPB and the EDPS call for a ban on that. So if this call is followed, it will take away quite a number of AI practices that honestly we should not want in our society. The constant monitoring of our entire behavior, our movements, our expressions, I personally don't see the added benefits, and neither do many others, including many members of the European Parliament, many civil society organizations, and so on. But then we go to the second step. What would be allowed? High-risk AI systems under the proposal will be allowed. They will have to meet requirements, but they will be allowed. And here it becomes more complicated, because the high-risk structure that the European Commission has chosen basically normalizes and mainstreams quite a lot of AI practices and uses that are still heavily scrutinized today for many reasons, not only because of bias, not only because of privacy risk, but for technical reasons, for societal reasons, for legal reasons. You can think of predictive policing, AI in the judiciary, in sentencing, productivity scoring of workers, allocation of social benefits. All these are on the so-called high-risk list that will be allowed as long as they meet certain requirements. And the question here is, are we ready for that? And more importantly, perhaps, is AI ready for that? I used to be a lawyer. I used to be a litigator. I went to court, and perhaps one of the most difficult things in that profession I found to be understanding legal judgments, especially those from the Supreme Court. the lines of reasoning, the interplays between the considerations, the balances that they sought, the trade-offs chosen. I mean, everybody can read a text, but truly understanding it and then even being able to apply it to a different case or a different set of facts, that is something completely different. And I would imagine that writing such a judgment is perhaps even more difficult. And that is why lawyers and judges go to law school. And AI doesn't go to law school. In fact, AI doesn't understand text. It finds a combination of pixels that corresponds with another combination of pixels, and then it identifies that as a pattern. And that pattern could be similar words, for example, or a pattern of similar sentences. But it has no comprehension of what these words or sentences mean, let alone how they could be useful. So AI that helps apply the law to a concrete set of facts, which is now literally on the high risk list, and which is basically what judges and lawyers do, applying the law to a concrete set of facts, seems quite a hefty expectation. But what is more important is that lawyering and judging is so much more than finding patterns in pixels or in historical data. It requires conceptual thinking, the ability to weigh circumstances, the ability to weigh interest, to see remorse or to see the absence of remorse, to see the possible precedence of a judgment. AI cannot do that. Perhaps it can never do that. So putting this specifically on the high risk list is a bit of an example that is overpromising and will be under-delivering, unfortunately. So this is where the Commission says, well, this is why we put down all these requirements. If it cannot do all these things, it will not operate correctly, so the accuracy requirement will not be met. I understand this line of thinking. I understand that the Commission wants to create a deterrent effect with this proposal. But it's a bit putting the cart before the horse, I think. We set the bar so high that it will automatically phase out all those problematic use cases. But will it? Will it phase out all the problematic AI? Or is there another way of looking at it? First of all, this is where we have to look at the requirements set for high-risk AI. They want the provider to have a risk management system, which is good. It's an obligation to think your system through and foresee potential adverse effects. They want high quality data sets. They want good documentation. They want human oversight. Interesting. They want accuracy, robustness, and cybersecurity. These are all elements of the ethics guidelines for trustworthy AI that Virginia and I helped draft in the high-level expert group. But what stands out, though, is that a number of elements from those ethics guidelines, these are captured in 7 requirements, are missing from this proposal. And most notably, perhaps the requirement on non-discrimination and fairness. And if the Commission hopes that high-quality data sets will deal with any discriminatory bias or unfair outcomes of AI, it overlooks the important facts that not all biases are the result of low-quality data. It's the entire system around AI that can cause biases to creep in. Now, as a sidestep, many people ask me why this non-discrimination or bias problem is such an issue. And then they say people are also biased. This is true, people are. And AI basically puts a great big mirror in front of our faces and forces us to take a long, hard look at ourselves and to acknowledge there is quite a lot of discriminatory bias going around in our society. But there are some important differences between bias in humans and bias in AI. And first of all, it's the scale. Where one person can be biased towards another person or even a certain group, the effect can be devastating, but it allows us to address this issue directly with that person. And because of the scalability of AI, these biases are also, because of the black box phenomenon, harder to detect, but they also affect a much larger group of people at the same time. The second difference is that AI bias can lead to amplification of existing biases. For example, when people feel confirmed in their own biased beliefs when AI presents them with the same outcome. And to give you an example, I've heard data scientists say that the data simply shows that there are more people from North African descent showing fraudulent behavior. They well know, this is well known as the data says so, or the computer says so. The third difference is that AI leads to an embedding of biases. And while we tend to believe that AI is truly self-learning and will improve itself, it only learns what we teach it. And if we don't teach it well, and we keep teaching it biases, it will embed these and enforce these biases even further. So this was a little sidestep, but another element of the ethics guidelines that is missing, strangely enough, in the proposal is privacy. And I mean not just the GDPR privacy, which is basically aimed at the use of personal data, but the broader concept of privacy, such as the one described in the EU Charter for Fundamental Rights and the European Convention on Human Rights, the right to a private life, which is a right that, by the way, also includes our physical, psychological, and moral integrity. And I find this really strange because the reasoning that the Commission followed for determining the requirements for high-risk AI is that these requirements can sufficiently mitigate the risk of harm to our fundamental rights. So privacy and the broad concept is a fundamental right. When we talk about facial recognition, for example, even when we talk about that, many discussions are about the fact that it is biased because it does not recognize people with darker skins. Well, be as it may, it won't be for long before facial recognition can identify people with all color skins, darker skins, lighter skins, in all conditions. It will no longer be biased. And then what? Being looked at and potentially being identified all the time, anywhere, affects our general privacy, our right to a private life. And as a psychological chilling effect, people might feel inclined to adapt their behavior to a certain norm, which in its turn affects our moral and psychological integrity. And there is legal doctrine and precedent that this chilling effect of surveillance can constitute a violation of the private space. And there are also stories that people might become more hesitant to, for example, participate in demonstrations. And that is another fundamental right. And while for facial recognition, the impact on our general right to privacy and our psychological integrity might be more obvious, you could argue that the indiscriminate on and offline tracking of all aspects of our lives through our online behavior, location data, our IoT data, smartwatches, health trackers, smart speakers, thermostats, cars, etc., and then used to push and influence and nudge us towards certain information and influence our opinions, is also affecting our moral integrity. I don't think that the requirements that are now set for high-risk AI in the proposal will always sufficiently mitigate all these risks all the time. And this goes for each and every use case on the high-risk list. So back to the other question, is there another way of looking at it? And I've been long advocating a human in command approach to AI, an approach where we ask ourselves question zero. Do we want AI to do what it claims it can do in the first place? Do we want it to largely take over the work of judges, of doctors, of the police? Or do we want certain decisions to remain the prerogative of humans, for example, particularly in domains where these decisions have strong legal implications or societal impact, such as in the judiciary, in law enforcement, in healthcare, in housing, in education? Which brings me to the final element that is missing, that is so prominent in the ethics guidelines and missing from the proposal, and that is human dignity. And at the high-level expert group, I must be honest, I looked it up yesterday and we described that quite beautifully. Human dignity encompasses the idea that every human being possesses an intrinsic worth, which should never be diminished, compromised, or repressed by others, nor by technology. And this means that all people are to be treated with respect and as moral subjects, rather than merely as objects that can be sifted, sorted, scored, herded, conditioned, or manipulated. And I hope that in the months and years to come, where many parties will negotiate and lobby this proposal, this will remain our beacon to preserve human dignity in a world with AI. Thank you very much.
Thank you very much for this kickoff and elaborating on the background and also the workings on this proposal and giving us some important things to consider. And I guess this is really nice as a starting point for the next presentations that we will have, because you raise a lot of important questions. And I think that human dignity is indeed an important issue to take at the center stage of this. Moving on to our next speaker, Tycho de Graaf. He is an associate professor in civil law, and his research and teaching covers civil law and focuses on technology and law. Together with his colleague, Professor Iris Wijsman, who is our next speaker, by the way, and thanks to the SAILS project, Tycho is currently researching private law aspects of AI. So Tycho, floor is yours.
Thank you very much, Bart, for your very kind introduction. I'll share the screen, which I have prepared for you. Okay. So as has become apparent, the proposal provided by the European Commission relates to both government as well as businesses in terms of, first of all, social scoring when speaking about governments, but also from a business perspective. And I will touch upon only in this presentation on the business perspective because the proposal is frankly too long to summarize everything. It's more than 100 pages, so I'm going to look at it only from a business perspective. So first of all, to get started, what does the proposal relate to? What is it actually? Well, it's internal market legislation, and it pertains to placing on the market and using of AI systems. It's product safety type legislation. And I say it's type legislation because generally product safety legislation regulates products and not technology. But in this case, the proposal will regulate technology. As far as businesses are concerned, this proposal pertains to vertical relationships between government and businesses. And enforcement of the act, of the regulation, will be done by national authorities. The AI Act seeks to do a number of things. First of all, it seeks to protect the health, safety, and fundamental rights, as well as improve the functioning of the internal market in order to ensure the free movement of goods and services, but also to avoid fragmentation, to avoid member states each coming up with their own AI laws, rules, and regulations. The AI Act applies to AI systems both as a standalone basis, but also AI embedded by means of firmware into physical products. It pertains to both providers who place their AI systems on the European Union market, but also has an extraterritorial scope. It also relates to providers who are located outside of the EU if the output of the AI will be used in the EU. So take, for example, a US company who has software as a service, which has AI providing advice on whether or not to select certain employees. And if that advice is provided to a company in the European Union who wishes to employ employees in the European Union, then the US company will be confronted with this legislation. So moving on to how it relates to other bodies of law, and as has already become apparent in the chat, there are a number of additional existing legislations which continue to apply. So legislation with respect to fundamental rights, consumer law, product safety legislation as liability, they are already in place, and this AI Act will be on top of it. It will supplement, it will complement this existing legislation. So whatever is in those acts is not something which is repeated in this AI regulation. So in terms of discrimination, if and insofar it's already covered by the Charter, it's not something which is going to be repeated in the regulation. That's something which a number of representatives of the European Commission have presented their proposal in previous webinars, have outlined. Whether or not that is successful or not remains to be seen, but in any case, that's the rationale behind not having a number of elements in this regulation which perhaps might have been expected in it. The AI Act is risk-based, so unacceptable risks posed by AI are prohibited. An example is that AI is used by having certain techniques which will influence and which will cause or likely to cause physical or psychological harm. If those techniques are subliminal, then those techniques are prohibited. I'm looking again at this from a business perspective, and any self-respecting business, I suppose, is not going to employ such techniques, so I will leave it aside for the rest of this presentation. What is more important for business is high-risk AI, and I will get to what high-risk is in a minute, but first of all, to say high-risk, as Katharina Muller has already indicated, is something which is permitted if the business complies with a number of requirements, which I will also get into in a minute. The third category of risk is transparency risk. So if the Google Duplex AI assistant, which you can Google, and it's quite an interesting example of AI calling, in this case, a hairdresser to try to make an appointment. If an AI assistant is impersonating a human, then the AI needs to inform the other party, in this case, the hairdresser, that it is AI that the hairdresser is talking to. And last but not least, there is a category of risk which has either no risk or a minimum risk, and that is not something which the AI Act pertains to. And my colleague, Professor Joost Ruijsman, will talk after my presentation about that in more detail. So what then is high-risk AI? Well, there are three categories again. First of all, it's AI embedded into regulated products, typically physical products. So if AI is embedded by means of firmware into a physical product and intended to be used as a safety component of such regulated product, then it is subject to this regulation if and only if it is also subject to third-party conformity assessment. So if you have a regulated product and you need to ask a notified body for improvement, for providing conformity assessment, then and only then is it subject to this act. An example could be a vehicle servicing lift. So if you have your car serviced at a garage, then the garage will typically use a vehicle servicing lift to put that car up in the air so that the mechanic can move under the car and repair the car. Insofar that servicing lift uses AI pursuant to the new machine directive, which coincidentally has been proposed on the same date that this regulation has been, pursuant to that, it requires a third-party conformity assessment, is also a dangerous machine and therefore is regulated and subject to third-party conformity assessment. Again, I must stress that there are many machines which are not subject to third-party conformity assessment. They are therefore not high risk and as such not subject to the high risk requirements in this regulation. The second category is regulated standalone AI. So if AI is itself a regulated product and it too is subject to third-party conformity assessment, then it is subject to this AI Act. An example could be certain health apps which use AI. They are maybe subject to the medical devices regulation because the medical devices regulation also relates to software, then that is high-risk AI subject to this regulation. The third category is AI used in certain areas. So if we take again that HR software using AI to provide selection advice, that is used in the HR area and therefore also high risk. Now, we've discussed a lot about when the Act does and does not apply, but if it applies and if it's high risk, what then are the obligations resting on providers? Well, first obligation is that the provider needs to design and develop the AI with training data free of errors, which is quite a high threshold. The AI needs to be sufficiently transparent to allow the users to interpret its output and to use the output appropriately. The AI, as Katharina Muller already mentioned, should allow for human oversight, so somebody should be able to hit a stop button to stop the AI from functioning. The provider needs to implement quality and risk management systems, as well as do an ex ante conformity assessment. So before he places the AI product on the market, he needs to have it be subject to assessment by a notified body, and that notified body will not only assess pursuant to the relevant sector-specific legislation, for instance, the machine regulation, Machine Directive or the MDR, but also on top of that needs to at the same time determine whether that AI system is compliant with the AI requirements in this regulation. If, however, you have AI in certain areas, the HR area, then an internal ex-ante conformity assessment will be sufficient. The AI should also automatically record events, or there should be logging capabilities. The provider should perform post-market monitoring and corrective action. So if something goes wrong, he needs to withdraw the product and recall it from the market. And if serious incidents occur, then he needs to report it to market surveillance authorities. Also, the user has certain obligations resting on him or her. He or she needs to use the AI in accordance with the instructions provided by the provider. He needs to monitor the operation as well as report the incidents to the provider and immediately suspend the use of the AI. Now, I have heard quite a lot of colleagues talk about the Tesla Autopilot example. Is that too subject to this AI Act? Well, actually not directly, because it's old type legislation containing very detailed requirements, and this act does not directly apply to it. But if in this case, motor vehicles regulation is amended, then the European Commission needs to take into account these AI requirements when amending the new legislation. So in summary, because my time is almost up, what is it? It's product safety type legislation, has an extraterritorial scope, relates to the placing on the market and using of AI systems. It primarily relates and regulates high-risk AI and does not deal with liability. So I'm very much looking forward to acts on liability. The European Parliament has made a proposal in October of last year, and the European Commission is set to propose something on liability at the end of this year and the beginning of next. Okay, thank you very much.
Thank you, Tycho, for taking this from a private law perspective. And also thank you for already on the fly answering some of the questions. Maybe you didn't see it, but in the chat there were already some questions that you answered while presenting this. We do take questions, of course, also for the other speakers in this block, but we do that after the next presentation. So let's move on to the next speaker, which is Iris Buisman, and she's a professor of company law at Leiden Law School since 2011. Her research and her teaching focuses on general company law, more specifically on innovative legal business forms, liability, and technology and law. And within the SILS program, Iris currently focuses on the private law aspect of artificial intelligence, together with Tycho, whom you just heard presenting, and on risk management and culture with Mark North. So Iris, floor is yours.
Thank you, Bart. Do you see my presentation? Yeah, okay. No, not yet.
Yes, we can see it.
Okay, great. Okay, so welcome everyone. I'm very happy that you all joined us today during our conference on law and AI, organized by the SILS team of Leiden Law School. And today I'm going to talk about the proposed AI Act, and then more specifically, the risk management requirements included in the proposal. And I'm focusing on corporations, organizations, companies that are actually developing AI systems in order to put them on the market, either externally, so that they provide them or sell them to third parties, or they actually use the AI system themselves in their organization. For instance, if they want to make the operations more efficient, or if they want to be able to provide work for the employees that's more interesting. So as Tycho already mentioned, and Katelijne also in the keynote of today, the European Commission took a risk approach in this proposal and identified 4 categories of risk AI systems. And today in my presentation, I will focus on the orange category, so the high-risk AI systems and the requirements that apply to those AI systems, but also to the yellow and the green ones, because we have Article 69 in the proposal. And that article actually states that providers and developers of AI systems that are non-high-risk systems actually can draw up and adopt code of conducts in order to actually comply with the requirements that are applicable to high-risk systems. So those requirements become relevant if providers actually adopt such code of conducts. And those code of conducts can be seen as part of soft law. And as we know, soft law instruments can actually have a legal effect depending on the jurisdiction and depending on the court. For instance, they can have effect through open norms such as reasonableness and fairness, or they can be seen as a common opinion when the code of conduct is actually based on code of conduct established by the sector as a whole. So thereby the requirements applicable to high-risk systems are maybe also relevant for those yellow and green AI systems, so to say. I would like to see the next slide. Yes. So the approach of the European Commission is a compliance approach, and they so the structure of the proposal is formed on the basis of the new legislation framework. And as a non-safety or non-product safety lawyer, that's actually somewhat of a puzzle, because it first focuses on the AI system itself, and then focuses on the obligation for the providers, and then focuses on conformity assessment, which also has obligations for the provider. So in order to actually get a whole picture of the obligations of a provider, you need to find the pieces within the regulation in different locations. Relating to the risk management system, which is the central point of my presentation, there is an Article 9, and that article is within Chapter 2 of Title 3, which is focused on the AI system itself. But it becomes relevant for the provider because of Article 17, which states that a provider should actually establish a risk management system as part of the bigger quality management system. And the requirements for the quality management systems are included in that Article 17. And that quality management system actually says you need to implement this risk management system, as well as within that system, written policies, procedures, and instruction in certain areas that are actually included in that Article 7, and which I have included in the green boxes of this slide. So we need policies and procedures and instructions related to data management or with communications with authorities. And one of the specific areas which I find very important is the last one, which is actually the obligation to construct an accountability framework, which means a framework setting out the responsibilities of the management and other staff with regard to all aspects of this quality management system. So zooming in on this, Siri is talking to me. So a little bit zooming in to the risk management system, the provider needs to establish, implement, document, and maintain this system throughout the whole life cycle of an AI system. And there's an exemption for credit institution because we have regulations, specific regulations for those legal persons. So this risk assessment is about adoption of suitable risk measurements. So when the provider performs a risk assessment, that is with the objective to actually identify suitable risk measures. But within the regulation, there are already some risk measures put in as an obligation. So those are two things. The provider can itself determine which suitable risk measures are necessary. And then in addition to that, there are already risk measures that need to be taken and are explicitly included in that regulation. And those are, as Katelijn and Tycho already mentioned, the 5 categories of risk measures that already have been explicitly included. So I'm not going to further dive into that. I would like to dive a little bit further into the risk assessment, because the regulation requires a provider to identify and analyze known risks and foreseeable risks of the AI system. So that's one of the activities of the risk assessment. Then the second activity is that it needs to estimate and evaluate risk that may emerge. And this is both ex ante, so before putting the AI system on the market. Well, my question actually is, what is the distinction between those 2 categories? Because don't we need to estimate and evaluate known and foreseeable risks? Is there a difference between known and foreseeable risk and risk that emerge when a system is used? So I would like to have a little bit of a clarification there. And then as a third activity, which is ex post, so after the AI system is put onto the market, there needs to be an evaluation of risk that has been apparent by the use on the market. And on the basis of this assessment, the provider needs to adopt suitable risk measures in order to eliminate them or to mitigate them. And if they want to mitigate them, then mitigation and control measures needs to be adopted. So the outcome of this risk assessment is that there is some sort of residual risk if the provider is not able to eliminate all of the risks, and this risk needs to be acceptable. So what happens is that with this approach, the provider does have a large discretion in this risk assessment. So the provider has to determine what constitutes a risk for health, safety, and fundamental rights, whether or not it can be eliminated, what adequate measures needs to be adopted, and what constitutes an acceptable risk. And in all of that, obviously, you can have different opinions. And this assessment is being done in an organizational setting. So the question arises, and I couldn't find the answer in the regulation or in the proposed regulation, is from which perspective is this risk assessment being done? And this leads me to a bit of the corporate law aspects of developing AI within a corporation. Because a corporation is led by the board of directors, and the board of directors has duties, the director's duties, and one of the duties is to implement an adequate risk system. But this risk system is embedded in the whole operation of the organization. So most of the times, the organization has a mission, a vision, a purpose, and a strategy. And the board actually defines the culture that is supportive of achieving this mission, vision, and purpose. And the board also defines the risk attitude. So if we're talking about risk assessment, this risk attitude is really important for the outcome of the assessment. And also the board demonstrates or doesn't demonstrate, if it's not doing its job properly, a commitment to values. And by doing so, they have to take into account a certain orientation. So we have stakeholder model approaches and we have shareholder model approaches. And in a shareholder model approach, the board of directors actually should take into account the interest of the shareholders, which is most of the time profit maximization. So for instance, in the Netherlands, we have a stakeholder approach, a stakeholder model approach, which means that the board of directors needs to take into account the interests of the company when deciding on certain things, but not damaging or harming the interests of the other stakeholders in an unacceptable way. So this is a different approach. And also this approach has an influence on how this risk assessment is being done. And then this orientation flows throughout the organization. So when the AI system is being developed and we have all those parties within the organizations that are involved in developing the AI system, the culture is important, the communicated risk appetite is important, the orientation of the board of directors is important. And that leads me to the approach in the proposal towards this risk management system, because the proposal is really focused on the AI system as a product on itself, on the product safety. It's a standalone approach. Whereas if you look at the risk management practices from an organizational setting, this is more or less focused on the whole system. It takes a holistic approach. And I don't think that you can actually include in such a proposal all these requirements without taking into account the organizational setting in which this takes place. And there are certain aspects in which you see the organizational setting is taken a little bit into account. So the data governance and management practices, the accountability framework, and the human oversight. But I don't find anything about the orientation of the duty of the directors, the risk appetite or the communication thereof, and also the culture of the organization. And we all know that that has a huge impact on complying to legislation is not included in this proposal. And actually, I think that the European Commission also knows this. And Katelijne already mentioned that probably those requirements in Chapter 2 and Chapter 3 will not mitigate all of the risks. And they actually took that into account, actually, because if you look at the enforcement, you can see that they actually make a distinction between AI systems that are non-compliant and the actions that should be taken if that is being identified and confirmed, and the AI systems that are compliant but still pose a risk in society. Also in that case, so also when you're compliant with the proposal, the authorities can ask the provider to take corrective measures or to withdraw the AI system or to recall. And I find it very interesting. If you compare Article 65 with 67, there is a difference between those. Because when your AI system is non-compliant, you have to bring it into compliance. Whereas if your system is in compliance, you have to ensure that the AI system no longer presents the risk. I think this is a flaw because obviously in Article 65, the aim would be to also eliminate the risk. But there's another thing is that in Article 67, they say a risk to health, safety, and fundamental rights. But then suddenly there is a new category of risks, namely other aspects of public interest protection, which I didn't see in Article 65 or in the preamble. So I find it very, strange or special that those are not in line with each other. And I wonder whether there is a reason to that. So coming to my conclusion, I think the proposal sort of intrudes into the organizational setting with this risk management requirements, but doesn't take account of the fact that it is part of a larger organizational setting. Thank you so much.
Okay, thank you, Iris, for taking this on a more practical level, because we can see that everything what is written on paper also needs to be implemented, and this risk-based approach is obviously something that will be challenging to make this work in practice. We have time for some Q questions and answers. I saw that a lot of questions were in the chat already, and they were answered also by some of the speakers, so thank you for that. We do have time for one, perhaps two questions before we move on to the panel. Is there anybody who would like to ask a question to one of the speakers right now? Please raise your hand if you want to. Yes, I see Frank.
Yes, sorry, and let me just say that I'm not the one expert, of course, but the question I asked that Katelijne answered was for me a bit difficult to process what the answer was exactly. So my question was a pretty concrete one, because I know, for instance, in China, the facial recognition and social scoring is implemented. But those unacceptable risk category AI systems, I myself wouldn't directly recognize in the EU. And I was wondering, because they are part of this proposal, if there are any of those laws that are currently enforced, or systems, I should say, that are currently being used, that would then be outlawed or something. I don't know what the proper word is, but pretty concretely.
I think the question was to me. As far as I can see, but please correct me if I'm wrong, as far as I can see, that what I call legacies, already existing and implemented AI applications, would not fall under this regulation. And I would call for the Commission to have them fall under the regulation as well, because otherwise you get a rush now towards implementing all kinds of stuff that we don't want. But correct me if I'm wrong, I could not find a very clear answer on that, but that is my first impression.
So then this proposal, just for clarity for me, is for future implementations, not for current ones.
As far as I could see, it would be for future AI applications. That I didn't see any obligation to withdraw things that are already out there. But I'm in very smart company today, so please correct, smart legal company today. So please correct me if I'm wrong here.
It seems to be the case indeed. But if people have some more views on that, please put that also in the chat, I would say, because then we can collect any perspectives on this. Well, since otherwise we would run out of time, I would suggest to move on to the panel, the first panel of today. But if you have any further questions to any of the speakers, please put them in the chat, because I saw that's very helpful that everybody can look at that and then try to answer that. It would be helpful, I guess, if you address a specific question to a specific speaker, because then somebody knows that he or she is being addressed. Of course, others can also try to answer questions that are being raised. So moving on to the panel, I would like to give the floor to my colleague, Eduard Vos Biaronga, who will moderate the panel, and he will introduce himself and also the panelists. So Eduard, over to you.
Thank you, Bart. Yeah, I'm Eduard Vos Biaronga, and I work at the ILO Center for Law and Digital Technologies. And what we are going to have right now, it is a discussion with several panelists that we have the very great honor to have with us. Thanks to the speakers that we had before, we can already anticipate that this is actually a huge step for Europe, in which it is bringing to the fore the huge respect for fundamental rights that we have in Europe, and that the advancements in AI are very much demanding for a greater attention, which in the past other technologies didn't really have. So we have an opening question to the panel, which is what does the AI Act represent for Europe, and what opportunities will it bring? And for that, we have three amazing speakers. We have Virginia Dignum, who is a professor at the Department of Computer Science at Umeå University in Sweden, where she leads the research group on social and ethical artificial intelligence. And she has been contributing so much to the field, the high-level expert group on AI, but also on the IEEE initiative on ethics of autonomous systems and other initiatives. So welcome, Virginia. We also have Angela Mueller with us. She's a senior policy and advocacy manager at Algorithm Watch, which is a non-for-profit organization committed to watch, unpack, and analyze algorithmic decision-making systems and their impact on society. So thank you also for joining, Angela. And together with them, we have also Andrea, who is currently an assistant professor at the Scuola Superiore Sant'Anna and adjunct professor at the University of Pisa. And also Andrea has contributed so much already with the RoboLaw project back in 2014, but then in continuation with the creation of the European Robotics and AI Center for Excellence that you have in PISA, and lately also contributing to the civil liability of robotics. So the question is to you. We have some time for having an open discussion with the speakers. So I'm going to ask you directly, Virginia, what do you think that this AI represents for Europe, and what opportunities do you think that this may bring for Europe and also for the world?
Thank you. I think that, thank you for having me here. And I would like to do two things, to answer your question, but also to raise 3 points, which in my view were not sufficiently discussed yet by the speakers before. Okay. Firstly, to give a bit of a background, I'm a computer scientist. I'm not a legal expert in no way whatsoever, but I have been working and developing AI systems since 1986. So I've been in the field longer than most people know that the field exists. One of the most important points that has not been raised yet, and which from a computer science perspective is our main issue, is that of the definition of AI. The definition that the AI Act is putting forward covers any software system ever built, and anything from your Excel sheet to system, to accounting system, to whatever else, everything fits under that definition. Software is based either on logic or on statistics or on learning systems. There is nothing else. So it is very important to understand what exactly does Europe want to regulate. I would say personally that I would like to see software systems being regulated when they are able of making automated decision making. And that can be any type of software system. And I would go further, any type of system. If an automated decision is made on my behalf using a dice, I'm as much concerned to have that regulated than if it's used some complex AI system. So that's one of the issues which is extremely important to make clear for all of us, for the ones developing the systems, but also for lawyers, and later for the ones who are going to verify and to check all of this, what exactly falls under the law and what doesn't fall under this law. The second issue is the combination or the potential overlap, or even worse, contradiction between this act and many other product law, the GDPR was referred already before, other technical recommendations and standards. So we do need to really understand, and especially if we are going to expect that small, medium companies also are able to deal with this law, we need to have a much more clear idea of how this integrates with other laws, and how much of the work is already done to comply with other laws, and what really is new and what really is going to be extra to comply with the AI Act. And finally, like I said, and maybe I didn't say it enough at the beginning, I'm very much in favor of AI regulation, or regulation of autonomous decision making. I'm very much in favor of that. I think that as a political statement, this act is a very strong one, but I see it as an extremely negative one. It is about the risks, is about what it's the finger which we are putting up. You shouldn't do this. I would rather much more see it as putting forward as a stepping stone for improvement of the systems that we have now, improvement of the applications that we have, and a stepping stone for innovation and for further research. AI is, and especially the AI systems that we use at this moment, are neither artificial nor intelligent. And we really need to work on ways that really provide the capabilities. And I think that in Europe, and research in AI in Europe has been always traditionally much more based and focusing on knowledge representation, on meaning, on understanding what it is, which is exactly what these systems that we have now. The problem is because they have no idea what they are doing. They are able to understand cats in pictures or cancer cells in pictures, but the system has no idea what's a cat or is a cancer cell and whether there is a difference between those two things. So the lack of meaning is what makes it not intelligent. It is not artificial because it's not only about the software. The software is the least of our problems. The issue of the social technical ecosystem in which we are using this software is really where we have to focus, and we need to focus on it from a positive, from a looking forward, and not just the finger telling what we should be doing or not. Thank you.
No, thank you, Virginia. So I gather from your intervention that there's still a bit much to do. One in framing, no, what is exactly that we are regulating. I think that this reminds me very much with the definition of robot, and I think that Andrea was working a lot, and also with Palmerini on the definition of robot, because basically that very much is going to determine what it is that falls under the scope of the regulation, no? But also I see that you have the hope that maybe we can turn a little bit like the negative tone of the regulation, and to trying to think how we can have a much more constructive approach into boosting a little bit the huge potential that this
we really have to take a future-proof approach. Data-driven AI, which we are looking at the moment, the successes of AI at this moment are data-driven, are driven and are being pushed forward by using increasingly more data and increasingly more computational power to solve a problem. We only can go so far in this road. It's not, we cannot solve all problems by putting more data into the equation or increasing the amount of computers calculating or finding the patterns on that data. Not all problems of the world are solved by pattern matching. So we really have to push forward, and there are those, we do have in the AI field, the scientific field of AI, we do have other methods and other technologies which can be used to really look at the problem from a different perspective. Look at the problem from the perspective of increasing the meaning, the understanding, the representation of knowledge, and also the reasoning about this, the knowledge, reasoning about what's there, and not just finding blindly patterns in data that the system doesn't understand. If we don't do that, we can forget about transparency, we can forget about explanation, we can forget about bias, we can forget about all these principles. We really need other approaches to solving the real problem, the problems that the data-driven AI has made a big mirror, or showed increasingly larger, made also increasingly larger. So the law has really to be looking at the next steps of AI and not at the AI that it's there now. The data-driven AI that we are using today is not something which we'll be using in 5 years. If the law is focusing on the data-driven AI, then we can stop. We don't need to implement it. We are too late.
Thank you. Angela, Virginia says that she is in favor of regulating ADM. What's your opinion on this, Angela? How do you see this new AI Act, especially also with regards with your work at Algorithmic Watch?
Thank you very much. So first, thank you very much for the invitation and also for the very, very helpful presentations heard so far. I'm looking forward to discuss that. Yes, so first of all, this is a preliminary remark. I very much support Virginia in her terminology. We also speak of ADM systems and of AI-based systems for a whole bunch of reasons, which maybe we can come back later. But still, like, AI is the terminology used here. And just like some brief points on that. So I think in general, just the recognition that the use of AI can come with risks, and that we need a framework for governance is something, of course, we welcome. And I think that is also because your question was, what is the opportunity this act brings? Of course, that is an opportunity for Europe. It could also be an opportunity actually to change a bit the narrative when it comes to the use of AI, so that it's really the goal that the use of AI is fostering, individual autonomy, freedom, the common good, and not reducing it. That could be the opportunity, so that it's really about this recognition of the need for a governance framework. I think for the world, its significance stems from its potential to really be on the one hand, agenda setting, because it really brings the topic once again to the top of the agenda, but also like when it comes to substance standard setting, because other states will have to justify like going above or below the standard that the EU now or the Commission now proposes. At the same time, of course, we see a lot of open questions with these proposals, and I think open questions, that's not just a euphemism for critique. There are some aspects where it's really critique, but there are also a lot of aspects where we really have open questions, because as said by the speakers before, it is a very complex piece of legislation, and it has a lot of interdependencies with already existing legislation, with planned future legislation, regulations, and so on. So I think this is really a bit hard to see what effects it really will have in practice in the end. But we have, I can list some. We have some open questions regarding the risk-based approach. We welcome, of course, the transparency requirements, because it's really our point that transparency is very important. At the same time, you have to be aware that transparency can only be a necessary condition. It's never a sufficient condition to ensure like an accountable and responsible use of AI. We have questions regarding the idea of like categorizing systems into fixed lists. For example, say these are users that are high-risk systems. We have another approach to that. We also have questions about its conformity assessment, some of which have also been raised before. We also have open questions whether the protection it actually aims to give through banning certain systems is really effective. And then we have like detailed questions, I'd say, about like the competences and resources assigned to national bodies and so on. But I think overall, it's really these open questions that also make us think whether the regulation as such can reach this goal of ensuring a use that is to the benefit of the society and not to its detriment. Thank you.
Yeah, thank you, Angela. Yeah, so I agree that one of the pillars has been transparency. With some colleagues, Aurelia Tamo, Christoph Lutz, Heike Felsman, we've been working on the concept of transparency and how can we really make it work, no? Because it seems that sunlight is the best disinfectant, but it needs also like to be taken into consideration what is the recipient of that transparency and how we're going to make them the systems and explainable and understandable for the other the demand side, no, of such of transparency. And I assume that given the complexity of these systems, this is going to be a challenge that for now, it seems that the regulator is putting back to the developers. So maybe hopefully with some of these requirements, it is going to improve also this black box phenomenon, no, that it has been so much discussed. Andrea, Angela mentions again also about the definition, and you worked a lot, no, on definitions, and so. But you also worked a lot on consequences and on liability because you participated on this amazing report on the European level. Andrea, what are your takes in this, on the definitional part of it, but also on the consequences that this may bring for society, for developers, and so?
So first of all, thank you for having me here today. And yes, before getting to definition, which is a very relevant issue, what I appreciate about the proposal, the European proposal, is the attempt of having a change of pace. So one way of putting it, after talking so much about ethics, we finally get to the law. And as a lawyer, I think this is an essential change of pace. Why so? Not because I do not believe ethics is relevant, but precisely because I am strongly persuaded of the importance of ethics. I do not believe we shall reduce ethics to the weakest form of soft law. So as it was intended by the European Commission and many other international organizations up until today, ethics was a substitute, a weaker substitute to well-conceived regulation. And I do believe that ethics so intended is harmful and doesn't deliver what it actually promises. And I was always a bit concerned with the fact that there is no clarity between what is actually ethics and what is law. Very often you heard people speaking about data protection as if it were ethics, but that is another branch of law. So the way taking things seriously, not just rights, like Dworkin says, we really need to distinguish ethics from law. And it is important that on this very matter, the European Commission starts talking about regulation, therefore law. And in this, I appreciate the attempt to exploit what we know as the Brussels effect, so the possibility of Europe in taking a stance and influencing beyond its own borders the international debate revolving around these matters. Otherwise, if it was stayed with the output of if it stayed with the output of the high-level expert group, that would be just another set of ethical principles next to the many other that are present in the international debate. And then the question would be, which I always asked, why should one pick the European ethical principles as opposed to the many others that are present and developed by other international organizations? So I'm happy that we start talking about regulation. Talking about regulation, of course, is very complex because regulation is complex. And I like to say, this is something that I learned while I was doing my LLM at Yale. But then I was working on financial markets, not advanced technologies. But one of my professors, while we were studying the consequences of the financial crisis, told me, and I remember, regulation is not a battle, it's a war. What does that mean? A war is made of many battles. So you don't fight it just once. We cannot be persuaded that we'll come up with a perfect regulation of anything that is the best regulation possible the first time around. Regulation happens in iterations. You first start regulating something and then you perfect what you did and you made some normative reform. That takes time, but that is how things are. And I do believe, and I do agree with Virginia to that extent, that we cannot look at where the ball is bouncing right now, but we need to try and guess where the second bounce of the ball is going to be. So, and in that perspective, definitions matter. And definitions matter. And of course, I'm not very happy with the definitions of AI provided by the European Commission. But the problem is, I think that you cannot come up with a satisfactory definition. One way of putting it, I'm about to publish an article with this very title, that is AI does not exist. And very much in the sense that, like Virginia was also saying, that it's neither intelligent nor artificial, but also in the sense that there is not one thing that is AI, and that is well reflected in the effort of the European Commission of having a very broad and all-encompassing regulation of AI that simply isn't possible. So in the study that you mentioned, I tried to come up with a definition of artificial intelligence and basically to discuss the possibility of having a definition of artificial intelligence, and I saw that actually there is not one thing that can be deemed artificial intelligence. The AI that is behind my cell phone has nothing in common with that behind of an expert system or a self-driving car. The kind of concerns they give rise to are extremely diversified. It very much depends on the domain of use of the different persons involved. This is absolutely clear and evident when it comes to liability rules. It would be disastrous if the European Commission attempted to regulate liability of AI unitarily. I am absolutely against that. It would be the wrong move. I do believe that we should go along the sectorial approach, the technology-specific approach, identifying classes of applications that are sufficiently uniform and pose similar concerns and address only those. In this sense, I believe policymakers' concern should focus on higher risk applications alone, or better said, those applications that are sufficiently close to the market as being realistic and allowing us to study and understand their functioning and their implication better, and regulate those that require an intervention based, I like to say, on law and economics considerations, for instance, to see the incentives that existing rules provide and adjust them when needed. So one aspect, however, that I believe is essential within the proposal, and I do think that that is actually beneficial, even if it's something that is largely incomplete and needs to be perfected, is the idea that some AI application can be prohibited. So in this sense, I do believe there is the meaning of the anthropocentric or human-centric approach that I believe, like Floridi, that is very essential in this field. I do believe that we should not we can very much, and maybe we should be concerned with the environment and how and pollution and everything, but that doesn't mean at all, and like Floridi says, that we need to disregard a human-centric or anthropocentric approach. Technology is a tool in the hand of human beings, and that is how it should be seen. So I'm a big fan of that, and I do believe that in this perspective, as a lawyer, a fundamental right-based approach is essential. And in that perspective, I do believe that considering some application as prohibited is the logical consequence. For instance, I'm very much concerned with the deceptive capacity of certain advanced robotics or AI-based applications manipulating human users, not only frail individuals. In this sense, I'm referring to Article 5 of the proposal. And I do believe that those hypotheses of manipulative technologies should actually be better defined, and actually the threshold of their illegitimacy a little bit lowered, because up until today, they are only illegitimate to the extent, illegal to the extent that, and therefore prohibited, sorry, to the extent that they, it can be demonstrated that they cause physical or psychological harm. And that threshold is way too high. It's impossible or very hard to demonstrate that those applications could actually cause physical or psychological harm, yet they could manipulate individuals' will, they could manipulate individuals' emotions in many ways that are matter of concern, and we could make a lot of examples in that sense. And therefore, I think that threshold should be lowered, because we don't want technology in an anthropocentric, in a fundamental right-based perspective, to manipulate human beings without them being aware to a certain extent. And so I do believe that those concerns are real, and I do believe that the attempt to identify those practices that should be banned is actually something that makes sense, and that should not be thrown away. Then, based on this, I believe that it was very wise of the Commission not to regulate liability within this framework. I do still hope that good sense will prevail, and we will have eventually a regulation for driverless cars, as we already have for drones, with respect to liability, but not the regulation of civil liability in AI altogether. because that would have very much an indeterminate object, and it would the proposal of the European Parliament can be harshly criticized, I do believe, in its internal structure. But so it was very wise to leave that out, and I do understand that to some extent it makes sense to lay some fundamental grounds for a broad set of application, even if it's very hard because the spectrum of things that fall under the umbrella of AI is extremely broad. So, but that should very much be limited in scope. So this regulation on AI should really be limited in setting some very firm points: the fundamental right-based approach, prohibited practices, and a few other things, not so much, and then leave the rest to very sectoral application. After all, up until today, we do not regulate capital markets together with consumer goods and traffic accidents and car circulation and air travel. All these are different and separate domains when it comes to liability and when it comes to other fields. And this is the legal technique that has been deployed at national and at European level up until today. And I do not see such a strong technological trait that suggests changing this approach, that would suggest we should unify all these sectors just because some form of AI-based application is used in these domains. But because there is not such a strong common technological element, and therefore absent such a strong technological element, I don't see a reason to change approach in regulation from what we did until today. That was clearly a sectorial approach.
Yeah, thank you, Andrea. To bring into perspective also some of your comments, and together with some of the discussion we're having in the chat, I guess that it is always a bit of a discussion in what is the role that ethics plays in the law and also in this domain. And I also, correct me if I am wrong, Andrea, but it seems to me that what you somehow wanted to suggest is that by having a soft law approach followed by ethics, this means that then we might have like a very weak way of regulating and of ensuring that the systems are going to be in accordance to the already established systems that we have. But
Yes.
that on the contrary, that the role of ethics should be, Virginia says the sky, not now the ground, but I think that I get you. No, Virginia, you want to unmute yourself. That's somehow like it's very much about like the grounds in which we are putting the basis, but then we have the law as somehow to enforce these.
No. I'm saying exactly the other way around. The law is the ground in which we can build. We cannot build outside the law. Without being outside the law, then we cannot be building nothing. The law gives us the ground over which we can build. It gives also the regulations, the compliance instruments to check whether we can build or not. Ethics is the sky, is where we would like to reach. It's if we put the ethics as the ground, we get moving sand because we don't know how to comply. Everybody has a different interpretation of what the ethics is. So law, and actually it's not my saying, it comes from Luciano Floridi in one of his many writings, but we need to build, and we need the law to be able to know where, what, and how to build. Without that, it's completely impossible to really build or develop any technology. Ethics is much more the guiding light, the direction in which we would like to do things. If you compare, for instance, with the food industry, there are very strict laws about what you can sell as food or how food has to be built and to be distributed and to be sold. So there are very clear laws about that. The ethics gives us the opportunity to differentiate business in terms of organic food or free-range eggs or fair trade bananas. Those are the aims that we would like to reach, but we do need the law to tell us whatever we get in the supermarket, we can trust that it's checked for whatever regulations are there.
Can I add something to this point? I agree perfectly with what Virginia just said. And I would also like to add one perspective as a lawyer, that not all ethical system is equally valid within a given legal framework. So just to exemplify with one very concrete example, because in the ethical debates, there are so many alternative models that are being presented. But for instance, if you take some writings about from transhumanist philosophers and the way they're defining human dignity as something that is not equally possessed by every human being, but is related to the level of rationality of the individual. Therefore, people with some form of mental impairment or children that are less rational would not possess the same amount of human dignity. And the fact that animals might possess also some degree of dignity. That is in clear conflict. That notion of human dignity is in clear conflict with the notion of human dignity that is received and enacted by European Constitution, the German Constitution, the Italian Constitution, the European Constitution itself. So I don't think we could take any ethical model, despite the existence, and that is of course a positive element, the plurality of ethical models, but not all ethical models are equal before the law or equally valid, because they do not all equally conform to the existing law. And constitutional values to some extent are a framework, like Virginia was saying, that kind of also limits and help us select those ethical models that we can use as a guidance. And this should be clear, because also in some cases, for some aspects, even utilitarian considerations that might be admissible in a specific field might not be admissible in another field when it comes to, for instance, to human machine interaction, the care of elderly and frail individuals. In all those domains, it's not so clear that each and every ethical model possible is equally admissible in light of constitutional values. So they are like kind of also represent the ceiling and the sky, our horizon within which we can look at the different stars represented by alternative and admissible ethical models. So this is a way I would also frame it. And of course, I don't want to convey the wrong idea that I'm against ethical considerations or ethics in technology. Quite the contrary, I take things very seriously. I'm just saying that because I do take them very seriously, I like to separate them and treat them as two separate fields, and not be mistaken that, for instance, data protection is ethics. I want my data to be treated lawfully, and that's not ethical. That's a requirement set by the law, and so because otherwise everything becomes blurred, you know, and that's
it was already a big tools many years, thousands of years ago, that somehow like was saying that the disciplines on its own, they are commenting on each other, no? Like, so basically, like the harmony, it is going to determine like how beautiful it is a song. But there are other aspects that they are going to tell you when you need to sing a song or not, no? So I think that in this case, there's a good idea of interdisciplinary research, so that from the inside we can communicate and build on each other, but also that then the different disciplines can be critical to each other, no? Angela, I want also to hear from you, because Andrea was very much suggesting on the idea of having a sector-specific approach. I also believe on it because my expertise is on healthcare robotics, and I always thought, oh, why do we have like some legislation on self-driving cars and also on drones, but we do not have something on healthcare robotics? Angela, because you're very much into the algorithmic decision making, do you see that much of a need of a sort of a specific sector approach or application-based model? Or do you think that despite of this, some common rules should be tackled or addressed in the development of AI?
Thank you. Yes, so yes and no, in a way. I really agree with the idea that we cannot like compare the Facebook algorithm with, I don't know, self-driving cars or something like that, because it's really something very different. But then again, we do not think it needs a sectoral approach. What we think it needs, and there our approach also deviates from the proposal of the Commission, is that we think we should really look at every system on a case-by-case basis, especially in the public sector, because this is one of our focus, but mostly because there are very, very unique legal and ethical requirements pertaining to the public sector, as you're all very well aware. So in the public sector, we really think we should look at every system. And then actually, it is only by looking at the system that you can say how much transparency we need on this system. So the more risk signals you detect for a system, the more like demanding should the more comprehensive should the transparency requirements be. And that does not really depend on the sector, as you say, because I think that it is also this idea of putting systems into lists and then assign certain levels of risks to these lists is somehow misguided in our view. And it can also be very dangerous. So it's really this approach that we think we should look at every system on a case-by-case basis. But I totally agree that not every system like that we should differentiate between different systems.
Thank you so much. For the sake of the time, and because I know that some of the speakers might also have to leave, I'm going to wrap up this session, the part one, by highlighting three different things that I heard. I say a change of narrative that we are having, the need for a change of pace, with respect to the ethics and regulation, but also that we are at war, not that much of the fact that we are at war, but on the idea of having iterative regulatory models that could be revised over time and that could become temporary benchmarks, so that at least for now, given the current understanding or the contemporary understanding of how things are, we could already establish certain safeguards to ensure that these systems are safe to use, but that, as I gather from you, Andrea, like the need of having a more a revision process into that, no? So thank you so much, Angela, Virginia, Andrea, for sharing the time and your knowledge with all of us. You're very much welcome to stay for the rest of the conference. Right now, what we're going to have is a short break, and we are going to come back at 15:20 when we are going to have the second part of the conference that we're going to talk about automatic detection of problems in Dutch legislation, but also a very interesting presentation from a colleague in the computer science department. So leave us for 10 or 15 coffee break time, and see you very soon. Bye, Virginia, Andrea, bye, Angela. See you now all.